about how to raise via NFTs, the legal lowdown. All right, so if you want to truly understand how to raise money through and understand the legal setup, I'm bringing on stage BCheque, Tom, Erika, and Charles. Give them a big hand, folks. And they will take it from here. All right? We good?
Thank you very much. Hi, everyone. Welcome to our panel on how to raise via NFTs. Obviously, there's a lot of interest in this area, as NFTs can be seen as a way to disrupt the traditional funding model. But there are obviously some unique challenges and risks. Fortunately, today I'm joined by legal experts from CMS, who are my former employers, though that's not the exclusive reason why they were chosen to be here with us today. I'm joined by Charles, Erika, and Tom, who specialize in this area, and together we're going to break down some of your key legal concerns. About me, my name is BCheque, and I'll be asking the questions today. I'm also a former lawyer, though I'm now full-time in the Web3 space. I write a Substack with weekly news on NFT developments and run a project which helps people to get access to airdrops on decentralized protocols. You can find me at BCheque1 on Twitter if you are interested. And I'll just hand over to Charles, Erika, and Tom before we get cracking to introduce yourselves.
Go ahead.
I'll go first. Hi, everyone. My name's Erika, and I'm an associate in the crypto and digital assets team at CMS. So we deal with everything crypto across the spectrum. We deal with the regulatory, transactional, so SAFTs and fundraising, which is what we're going to talk about today. Also, before that, I was legal counsel at a crypto payments company called WireX. And before that, I was already in the crypto community for about 3 years. So in total, about 5 years now.
Thanks. Yeah, so I'm Tom, and I work in the team with Erika and Charles. I've been doing weird things on the internet since about 2016, and am now able to sort of be a trusted advisor in the space to people with innovative ideas. So I have been involved in the Ethereum and Chainlink communities, and am part of far too many Telegram groups. But yeah, we have a bit of fun advising clients on all the risks associated with what they're doing, without trying to break their dreams too much. So yeah, it's a bit of fun.
And I'm Charlie. Hi, everyone. So we all work together in this crypto digital assets Web3 team. It's the only specialist team in the UK doing this. Essentially, we're crypto people who are lawyers, and that's the key to being able to do this work.
Indeed. Charles was someone when I was at the law firm a couple of years ago who, if you were interested in crypto or blockchain at all, everyone was always directing people to him. So really grateful to have them with us today. So just one other final kind of legal point. Needless to say, none of this is official legal advice. If you do have any specific questions, because all situations are very, very specific, I'm sure they'd be happy to take some questions at the end. So one of the first questions, which I think is super important from a legal standpoint, is what kind of regulations apply to NFT raises, NFT projects, and why?
I'm going to do this really quickly, and we can get onto the fun stuff as well. So you know this, right? Don't issue securities, and don't facilitate money laundering. If I'm speaking from the regulator's perspective, I can sum it up in those two things. The rest of it is kind of footnotes to that, but some of the footnotes involve needing a license, how you de-risk, how you do these things. I think the key thing to say is, so sometimes there's a perception that you talk to lawyers about this and they tell you what you can't do. We'll tell you what you can't do if you ask us, but we'll tell you what you can do. And we've worked on over 60 NFT projects, which are split down the middle. About 30 or so crypto builders, developers, projects, protocols, and about 30 are just digital collectible brand extension for sports teams, art galleries, museums, TV production companies, you name it. So I think if you only remember one thing, this can be done legally, and it happens all the time. There are lots of projects that don't get advice. We can talk through the risks of that as well, but it can be done working with lawyers.
Great. Second question around marketing, and this is something which is a big issue, probably related to the securities question, is what do you feel is appropriate that can be promised? Because having participated in the space for more than a year now, and I guess if Tom has been in for much longer in various Telegram groups, various promises are made, and what type of language or what type of promises do you think is appropriate?
Yeah, this is a really interesting space, and we spend time talking with clients all the time about how they can advertise and market their various offerings. And one of the key things to think about, and something that always comes up, is promising some type of return or APY, that someone could expect to receive, and anything like that. The ASA has given some guidance that you'll need to have documentary evidence to support that. So you can't, put an ad up on the tube that promises some 10,000% APY or whatnot without actually, being able to kind of stand by that. There's various other things too that you need to consider, such as letting people know that they've got to be liable for their own taxes, and that these things are unregulated. The value can go up as well as down. So things like that need to be thought about, but people have to kind of make use with what they've got. So if you're advertising, on a billboard at a football match, it might be quite different to providing an advertisement on a website where you might be able to provide more information. So there's some reasonability that's kind of understood within the space, but certainly there's some guidance, and that's what we spend a bit of our time sort of advising people in respect of, so they can follow the rules. Yeah.
That makes a lot of sense. One of the things which people reach out to me the most with, given that now I'm a writer in the space, building my audience, but people kind of know that I used to be a lawyer, is these commercial rights and the licenses involved. Obviously, when NFTs first blew up last year, one of the biggest selling points seemed to be that, okay, you own the commercial rights, you can go and do things with those, and people were very, very excited about that because it was a fairly novel mechanic. The criticism of the documents written seemed to be quite large in that it's quite a difficult thing to draft well. So what should people try to do when creating those documents?
I think in that regard, we probably need to go back to token standards, and it's something that people don't tend to look at when you're thinking about standard terms and what rights transfer with an NFT and the IP rights that transfer with it. So usually when we talk about NFTs in the mainstream sense, it's generally what we call pointer metadata NFTs. So the NFT itself does not contain the actual bit of work that you are looking to buy. So say, for instance, there is a piece of artwork behind an NFT. Perhaps the NFT itself is not the actual artwork. So it's the artwork that will contain the rights that transfer. So in the event that you look at pointer metadata NFTs, yes, you will then have to look at the standard terms. But before we get to that, you've also got NFTs whereby you can code the rights that transfer with those. So with that, there's no ambiguity because you can see on the blockchain exactly what's been coded. You know exactly what you're getting. You know what's being transferred. And that's good. But the problem with that is uploading data on the blockchain is very expensive, especially with gas fees. So people don't tend to do it. So now we go to the more common NFTs, which is the pointer metadatas. So just kind of going back to the standard terms and the commercial terms that that you had just asked about, I think a lot of it will depend on exactly what rights it is. Firstly, what kind of business you are, and secondly, what rights exactly you want to transfer. So there are so many different types of these terms. There's not actually any one standard license or anything like that. It's all, what are you looking to do? Are you looking to transfer literally everything with the piece of work that comes with that NFTs, or are you looking to sub-license certain parts? So that's something that we do a lot at CMS. So it is very much tailored to each project. So I think that's probably a common misconception that there's going to be a standard, but unfortunately, in this case, there isn't. It's just thinking about exactly commercially what it is that you want to transfer to the person that you are selling the NFT to, and any further transfer rights there, any sub-licensing rights, and yeah, so.
I think I'd say on that the context is all important, because the other way around, if we're doing this for a big international brand, there's always some point in the project where someone there pops up and says, for God's sake, check that we're not inadvertently transferring $1 billion of IP. So if you're in the crypto space, you're building things, you've got that kind of choice to make, as Erika says, around the functionality and what you're prepared to offer. If you're doing it as a brand extension project, critically, you have to make sure that you are not transferring intellectual property. That would not be the point of the project.
Just a follow-up question on that, because I've been on calls with lawyers and projects, and sometimes I find that the projects, and this might apply to some people out there, because of the spirit of the Web3 community that are very kind of community focused, they do have a particular view of what they would like to be reflected in the documents, but the lawyers do not seem keen, or would, it's kind of obvious that they would kind of caution at that being so kind of generous in those terms. How do you guys think about that balance between allowing community members in versus holding on to your rights?
I'd say it starts with a translation job. So the first thing that someone in our position is going to be doing is trying to pull out the point exactly that you're raising. So what's the expectation for the project? And what's the expectation for the customers? We've touched on that point around marketing. And I think it's not just the regulation and what the Advertising Standards Authority says or anyone else, but it's just good business to give people what they're expecting. And if there's any ambiguity about what they're buying, what they're getting for their money, it needs to be resolved. Nothing good will happen in those situations. And you're right that people come with certain assumptions and expectations on both sides of it. Things that are in smart contracts are opaque, so it's got to be surfaced somehow into whether it's the white paper or FAQs or something on a website. How you get this information out so that you're telling people what they need to know before they're parting with their money. The others will have something on that as well, I think.
Yeah, it's an interesting thing to think about, because the space is full of a whole lot of creative minds, and the goal isn't always to make money. A lot of the time, the goal is to have fun, and that's why the space is great, and we all enjoy working in it. And that's where I think your traditional lawyer might not get it, and might not really understand those kind of conversations with founders in this space about why they want certain people to. Or why they want it to be a little bit more relaxed. It's a community environment, and we don't need to set out every single right and obligation and make sure everybody is following the rules and this, that, and the other. It should be a little bit more freer. I think that's kind of part of why we're doing what we're doing and doing it in the way that we are is because we understand that, and that's probably. Where you start. And if you don't start there, you start somewhere else, and that's when conversations with lawyers don't go the way you want them to go. So
I think it's worth saying that part of the reason that we built the group is to have people who've been participants in these projects for a long time, because if you're talking to a lawyer who's got no personal experience of it, it wouldn't be apparent to them that these issues exist. They will not necessarily ask the right questions, or they'll only know what you tell them. So from our perspective, it's getting a team of people who are able to interrogate the architecture and the tokenomics and say, hey, did you mean this or that? Our starting point in relation to projects is to get the white paper and send a lot of questions back. There's a lot in every white paper that's not covered. And I guess having that expertise around other projects help with it. So starting with the household names in the space, and then working through to the builders in the garage, you get a sense of where people are trying to sit and can therefore kind of fit in with their model, rather than applying a kind of, this is what lawyers do, or this is what we did before, or we work with precedents because we're lawyers, so here's the last one, you can have that or nothing. You've got to be prepared to be flexible around what the project is rather than what your last one was.
Absolutely. So I hope that's super helpful on the kind of topic of documentation, but you also mentioned money laundering at the beginning, and I was wondering, one of the big things that's very different to normal commerce is that we're often dealing with anonymous buyers now in this space. So what should projects be thinking when raising money from anonymous people?
I'll kick us off by saying we were encouraged by the Elliptic report that said using NFTs to launder money is about the worst way you could find.
I guess it would depend on each jurisdiction, really, because each jurisdiction has its own rules. So, for example, the BVI currently doesn't really have a crypto regulatory framework, so that covers the whole anonymous buyers, the AML and KYC issue. But I think even if different jurisdictions don't have this regulation, you have to kind of go back to first principles and look at what FATF are saying. So they are obviously kind of trying to govern the whole issue of KYC and AML, and there's this VASP rule, that the travel rule, effectively saying that if any crypto transfers between wallets, you need to declare beneficiary name and the sender's name. So I think there will be, in some respects, that it will kind of go back to that, but also each jurisdiction will then try to be competitive and be more friendly to crypto businesses. So they'll probably relax the rules a little bit more, but I think that's probably the first thing we need to look at when looking at anonymous buyers.
Yeah, it's a really good point, and it's part of a much bigger kind of discussion, really. This question, and that is about different nation states competing to get the regulatory environment correct. So it kind of manages, encouraging economic activity within their jurisdiction, but also protecting consumer rights and ensuring that people get a fair deal in whatever they're partaking in. So, one of the first kind of things, and Erika alluded to this, that we kind of talk with clients about is how to kind of structure their operation in a way that deals with, the regulatory things that come up that relate to their particular business model. So very quickly it goes from an idea to a white paper to a multi-jurisdictional operation that has various different entities, perhaps with service agreements, terms and conditions, privacy policy, and whatnot that's required to kind of get them operating in a way that that fits in with the regulatory environment that they're operating in. So it's a bit of a journey that we go on with clients, but it's a very quick move to that kind of structure that's required.
And I'm just going to say, does everyone see the token issuance vehicles as BVI companies? Everyone sees the BVI in these things? Some do, some don't. So the reason for that is the background to what Erika's saying. In the UK, money laundering rules apply to firms in the UK that are exchanging or custodying digital assets. You've got to register. The rules are different in different jurisdictions. As Erika says, the BVI is easier to comply with in that respect. You still need to be very alive to the Financial Action Task Force. That's FATF saying nobody thinks that there should be money laundering in this space. I think it's hopefully goes without saying. But the reason you see so many projects launched out of the BVI is because of the time and cost involved in the UK registration. So that has become conventional in the market in order to address that point. The UK, as the others are saying, wants to be at the forefront. It's one of the jurisdictions that's competing to be a good home for this. So we're seeing resource put into the regulator to ensure that there is a quicker turnaround, a sophisticated response in relation to those applications. So you get the license application issued relatively quickly by people who understand your business and are asking good questions about how you're managing risk. The point around the EU, so MiCA generally gets a bad press with crypto people. perceived to be looking at crypto through a TradFi type lens. So it's kind of, the European Commission doesn't like unhosted wallets, for example. The benefit you get from something like MiCA, though, is harmonization across jurisdictions. So we touch on the point that the laws are different everywhere, but you get a license under MiCA, you got a license that's good for 27 places. So there are trade-offs in every one of these projects. You're looking at trade-offs, and I think that's part of the point that we're trying to say. There isn't we don't pull something off the shelf and say, here's how you do it. We have to understand what you're trying to do, explain the options, the trade-offs, the risks around it, and then you've got that structure that Tom and Erika are talking about for actually getting the project safely launched.
Yeah, I'm really glad you took the discussion into the realm of jurisdiction, because that's one of the questions I get most, where I think maybe for tax purposes, people are also considering it. Based on the current noises and the regulations that you've seen, where do you think this is a good place to be setting up? Like, are we positioning ourselves well to be at the forefront of the NFT kind of movement?
Well, we were just in Lisbon at the Web Summit, and everybody is there. There are so many movers and shakers that have decided to go there, as well as some other jurisdictions, of course. But you can see that other jurisdictions are doing maybe a better job in certain respects. But I think that the UK is taking an approach that works for it, and it's yet to be seen which approach is the best for so many different reasons. And it's not a question, I suppose, that is our job to answer. It's the politicians, and whatnot. But I think that there is definitely a role for the UK to play, and it's certainly a great place to get started. But I think, as we've kind of alluded to, there are certain aspects to this area of business that currently require you to have some perhaps offshoring of your model to make it work. Unless you want to go down the path of obtaining a license or a registration or whatnot, which can be costly and take time. There's pros and cons, I think.
So I actually think that maybe the UK is heading towards the right direction now, especially with Rishi Sunak coming in. He is very pro-crypto. There's also a draft bill being passed at the moment in Parliament under the Financial Services and Markets Act 2000, which effectively brings crypto assets within a statutory definition, right? So it brings clarity within what it is that we're trying to do. Whereas at the moment, what we're just working with traditional financial regulation principles. So it's a little bit difficult to apply what's already existing to things like crypto and NFTs, because these things are innovative, and you cannot just use hundreds of years old worth of legislation to try and apply that. It's just not going to work. So I think with this draft bill being passed, there's definitely potential for there to actually, for the law and the government and just kind of society in general to really see just how powerful the innovation is behind crypto, and thereby then protecting whoever is in the community accordingly.
I'm going to add, so we'll all give an answer to the question of why is London a good place? And we're all here. The first point might be a surprising point. So there's a huge talent pool in London. And is that surprising? Because these are internet projects. So why do you need people to be in the same place? I don't know what the answer to that question is, but somehow it makes a difference if they are. So having events like this, people like you, people like Tom and Erika, if you get the talent working together and some of that is being physically connected to each other, that's very powerful. So I think we have that, as well as the political support. And then the bit that probably nobody apart from me in this building is thinking about at the moment. Crypto is two things. So crypto, our definitions come from regulation, by and large the money laundering regulations. So crypto is anything that runs on a blockchain. You will start to see the traditional financial markets, financial market infrastructure is moving onto the blockchain. People will have seen the JP Morgan DeFi loan that was completed this week and publicized on Twitter. And that shows you, it's an illustration that blockchain is newer, better software for doing the things that the software that ran the financial markets has been doing before. So all of those transactions, the bond issues, the securities issues, the equity issues, will be crypto assets within the next few years because they will be running on a blockchain. So as different as they are to Bitcoin, Bitcoin is never going to be a security because there's no issuer, it's not redeemable, it doesn't have any of the characteristics. Securities get regulated because there's an entity that issues them, and there's an activity involved in doing that. So for the software, the protocols, there's no entity, there's no activity. That's the thesis of DeFi. There definitely is in TradFi, but TradFi is moving onto the blockchain. So everything that we're talking about here is being soon mirrored in a different parallel QEii conference center next door, where all of the bankers are moving their transactions onto it. And the UK has been a financial center for even longer than I've worked. So that is a critical piece that the UK government is trying to get. It's trying to get innovation around crypto, as you guys are thinking about crypto, but it's trying not to lose its position as a center of financial markets when all of the traditional financial instruments have become crypto assets, and it's happening now. Keep watching for that.
I think that makes a lot of sense. Although I did see that Rishi said that he would prefer a basket of Bitcoin and Ether versus CryptoPunks and Bored Apes. So, you know, he's...
I think that was a very wise answer to that question, so that he didn't immediately lose, 50% of all the crypto enthusiasts out there. He answered that as well as he could have for someone that perhaps doesn't have as much kind of expertise in the space as many others. So I think he did a good job.
Yeah, he hedged it pretty well, I think.
Yeah.
Really good. Next question. How can you manage funds in different cryptocurrencies? Because projects often now are going to get paid in one currency. Is there a smarter legal way to go about this, or is this just something that people need to practically manage themselves from an accounting perspective?
I think it's definitely an operational thing. This is actually not a legal question at all. So it's, in fact, it is a good thing that there are different types of crypto assets that are stored in different wallets, because if you start pooling all of these assets into one wallet, then you're going to get into the question of whether or not that's a regulated activity, because that's kind of similar to the pooling of funds, which is, not to bore you too much, but it's called a collective investment scheme in the financial regulation world. And once you kind of get into that, you're in all sorts of regulatory obligations that you need to comply with. And the aim of the game is to try and not have to try and bypass all of those things. So it's certainly an operational question. And we would usually suggest actually keeping these funds in separate wallets is most ideal. So if you have the capacity to be able to do that in the back end, then do. That would be my advice.
That question, I think, is also one which a number of participants in finance are deciding is too hard for them, and they instead, are looking to custody providers, to custody assets. People, perhaps you're running a business, you don't want to have to use an offline hardware wallet and and manage seed phrases and accounts and all this sort of stuff. And that's where, this space that's developing, custody of digital assets is growing. So that's a whole industry within an industry.
Of course. We've just got probably time for one more really important question, which I have, and then we'll wrap up. One of the really big selling points of NFTs for a long period of time, at least, was that it would allow creators to get secondary royalties. Like, it was one of the huge selling points at the start when I got involved. It was seen as groundbreaking that people could make these sales and then keep earning money in perpetuity. But what we've seen in the last few months is this kind of race to zero, but as different marketplaces have launched and people giving sellers the option to cut out the creator. What's the legal position here for creators who think that they have said, well, I would like 5% of every sale in perpetuity of this asset? Is there anything they can do? Are they entitled to that? Or are they just at the mercy of the market?
So I think, again, this is a question, firstly, to do with token standards, because there are different types of token standards with NFTs, whereby the smart contract gives you the automatic right to receive royalties upon transfer of the NFTs. And I suppose from a non-legal perspective, that would be the default position I would probably take. If I were to mint an NFT, I would try and use a particular standard whereby you get the automatic royalties. But if that is not possible, then again, we revert to the agreement between the marketplace and the primary seller. So it will all be a negotiation between the two, and although I appreciate a lot of marketplaces probably have their own standard terms, and it will probably end up being, we will take X amount from your royalties. I mean, it's always worth negotiating that, but whether or not there will be pushback, that we're not entirely sure. At the moment, I think creators are not protected enough in the NFT space, and we certainly need to do more with regards to that. But the market at the moment is definitely in favor of the marketplaces, unfortunately. But I think moving forward in future, there will probably end up being some sort of standard in terms of the IP rights that get transferred, especially to do with the royalties. And that is something that needs to develop between people in the market and also, I guess, lawyers once there's some sort of union that happens there. So
I just add, because it's bad that I'm so much older than everyone else and I'm the person who always brings it to the IRL bit. So you two are talking about it from the kind of crypto native perspective, but the traditional art industry market is coming to this very quickly. So we had connections there, and a year ago, 2 years ago, they just thought this was all nonsense, not something for them to be involved in. But now they see it as something that they are coming to, and they will drive, I think, some of the commercial standards around it that would fit into the smart contracts.
Makes sense. Thanks, guys. We've run out of time. Thank you very much. If you have any other further questions, please reach out to these guys after.
Can I just say one thing, which is very quick? So we're conscious lots of projects don't get advice. Lawyers are not all terrible people. We've got friends, they don't all work with us, who get how to launch these projects. If you want to scale, you have to comply with the rules. That's the final point from us.
Give a big round of applause, guys. And remember, when you're trying to raise money, keep in mind jurisdiction.